administration of justice, we in the judiciary are living the spirit of Article 1592C of the Constitution that instructs the judiciary to promote alternative forms of dispute resolution. It is for this reason that the judiciary's strategic vision, that is to say, social transformation through access to justice, STAJ, has made the mainstreaming and enhancement of uptake of alternative forms of dispute resolution a key strategic outcome that the judiciary is pursuing going forward. Ladies and gentlemen, as a judiciary, we appreciate that arbitration is not a self-contained system. It relies on the support and cooperation of national courts to ensure its effectiveness and legitimacy. In this respect, the enforcement of arbitral awards is perhaps the most important stage of arbitration, as it gives effect to the parties' rights and obligations as determined by the arbitral tribunal. Without effective enforcement, arbitration would lose its value and attractiveness as a means of dispute resolution. Put differently, without enforcement, arbitration becomes meaningless and futile. Without enforcement, the CE says again, arbitration loses its credibility and legitimacy. Without enforcement, arbitration fails to protect people's rights and interests. Therefore, it is essential that national courts adopt a pro-arbitration and a pro-enforcement attitude when dealing with applications for recognition and enforcement of arbitral awards, both domestic and foreign. In the Kenyan context, the commitment to enforce arbitral awards is evident from the legal framework put in place to regulate the arbitration process. The Arbitration Act of 1995, for instance, at Section 36, adopts an approach that courts should recognize and enforce arbitral awards unless compelling reasons stipulated in Section 37 are shown to exist. Kenya is also a signatory to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958. I digress a bit. The mention of the city of New York evokes fond memories in my mind and that of the former Attorney General who is here with us. The details shall be elaborated later. This obliges Kenya as a contracting state of the New York Convention to recognize and enforce foreign arbitral awards in its territory, subject to limited exceptions. However, as we all appreciate, laws on their own are insufficient. They need to be backed by courts that are pro-arbitration and pro-enforcement. As I see it, courts that are pro-arbitration and pro-enforcement have a dual responsibility. On the one hand, courts must respect and recognize the autonomy and decisions of the arbitral process. On the other hand, courts must ensure that the enforcement of arbitral awards does not contravene public policy or the basic principles of justice outlined as grounds to refuse enforcement in Section 37 of the Arbitration Act. The question that follows is whether our courts have embraced this dual responsibility. Ladies and gentlemen, I am proud to state that our courts have consistently recognized and enforced arbitral awards, except in rare instances where there were compelling reasons for refusal, recognition, or enforcement. Our courts have also recognized the importance of respecting party autonomy, finality of awards, and limited court intervention in line with international standards and best practices. This pro-arbitration and pro-enforcement stance not only promotes business confidence, but also eases the burden on our court system, freeing the courts to deal with other disputes. The jurisprudence that has emerged from our courts is that the grounds for refusing recognition or enforcement of an arbitral award are very limited and narrow, as set out in Section 7 of the Act. These grounds are not meant to be used as a pretext for re-examining the merits of the dispute or interfering with the arbitral process. They are meant to protect the integrity and fairness of arbitration, as well as the interests of justice and public policy. Some of the notable cases that illustrate the pro-arbitration and pro-enforcement stance taken by the courts are: one, Open Joint Stock Company versus Gibb, that's one case, and then where the High Court of Kenya enforced a Russian arbitral award and found that the respondent had waived his right to challenge the award by participating in the arbitration proceedings versus Scene Construction, where the High Court declined to recognize and enforce the International Arbitral Award on the ground that the arbitral tribunal had, in contravention of the arbitration agreement, applied English law as applicable and governing law instead of the laws of Tanzania as prescribed by the parties. There was sufficient evidence on record to show that the arbitral tribunal would not have arrived at the same determination had it applied the laws of Tanzania. And then yet another case, Royal Exchange PLC. In Nyemba, the High Court denied recognition and enforcement of the International Arbitral Award on the ground that the respondent was not served with the requisite arbitration process notices and pleadings, and was therefore denied an opportunity to participate in the arbitration. The same actions were held to be in contravention of the respondent's right to fair hearing and fair administrative action. The High Court determined that the applicants they demonstrate that Kenyan courts have shown their commitment and willingness to enforce arbitral awards in a positive and constructive manner. By adopting this pro-enforcement approach, our courts have shown an appreciation that enforcement of arbitral awards is not only a legal imperative, but is also an economic imperative. What I mean by this is that by enforcing arbitral awards, the courts have upheld the rule of law and fostered a culture of compliance and accountability. In addition, by enforcing arbitral awards, the courts have enhanced the confidence and trust of parties, especially foreign investors, in our legal system and our business environment, thereby fostering economic growth. However, as arbitrators and enthusiasts of arbitration participating in the Nairobi Arbitration Week, I challenge you to work towards improving our arbitration practices to reduce the possibilities for challenges to enforcement of the awards. This is so given that high-quality arbitral awards from good arbitrators compels court support for the acceptability and enforcement. I urge you to strive to be impartial arbitrators who observe procedural integrity. When these expectations are met, then we would reduce the number of cases involving challenge to the enforcement of arbitral awards. Ladies and gentlemen, to conclude, the enforcement of arbitral awards is also closely linked to the overarching goal of putting in place a people-centered justice system that we are championing under STARCH. By enforcing arbitral awards, the courts advance the agenda of people-centered justice, which is an approach that puts people at the center and has its purpose and its design the goal of equally meeting the needs of all people who seek justice. People-centered justice recognizes that people have different justice problems and preferences, and that they need different options and solutions to resolve them effectively. People-centered justice empowers people to participate and engage in the justice process and to achieve outcomes that are fair, satisfactory, and sustainable. That is why the role of the courts in enforcement of arbitral awards is so crucial. The courts are not only fulfilling their constitutional mandate to administer justice, but they are also enabling people to access justice through arbitration without frustration or failure. The courts are not only respecting the will of the parties who choose arbitration as their preferred mode of dispute resolution, but they are also ensuring that their choice is honored and enforced by giving effect to the arbitral awards. The courts are not only facilitating arbitration as an alternative to litigation, but they are also promoting arbitration as a complement to litigation in achieving people-centered justice. As we celebrate the Nairobi Arbitration Week, I urge all stakeholders involved in arbitration, including arbitrators, lawyers, parties, institutions like the Nairobi Center for International Arbitration and the Chartered Institute of Arbitrators and academics to continue promoting arbitration as a viable alternative to litigation and cooperate with each other and with the courts in enhancing its quality and credibility. I also encourage all participants to take advantage of this platform provided by the Nairobi Arbitration Week to share their experiences, insights, and perspectives on various aspects of arbitration, including enforcement of arbitral awards. I hope that this will foster dialogue, learning, collaboration among all members of the arbitration community in Kenya. I thank you for your attention and wish you a productive and enlightening Nairobi Arbitration Week. Asanteni sana. On Justice Martha Koome, EGH, Chief Justice and President of the Supreme Court of Kenya. Delivered. Justice Supreme
I'd like to invite Chair of the NCIA to present Justice Smoky Mandela with his gift from NCIA. Hello, Justice, I will invite you back to the podium. May I request that we give another round of applause all protocols observed. I would now like to introduce the moderator who will lead the discussion of the panelists who will be taking us through the role of the state court in enforcement of Arbitral Awards. The keynote address has set the tone for this panel discussion because, as we know, in as much as enforcement comes towards the tail end of arbitral proceedings, it is a crucial point of proceedings because it is determinative of whether or not the successful party in arbitral proceedings would recover. So without much further ado, I would like to invite Mr. Kamau Karori, Senior Counsel, to the stage. Please let's give him a round of applause. Mr. Kamau Karori is a senior partner and lead of the Dispute Resolution Practice Group at DLA Piper Africa, Kenya, Iseme Kamau and Mayama Advocates. With over 25 years post-qualification experience, he's a senior counsel and a chartered arbitrator, and he's also one of Kenya's representatives in the International Center for Settlement of Investment Disputes panel of arbitrators. You can find his bio at page 21 of the program. Welcome, Mr. Karori.
Thank you very much. My lords, Judge of the Supreme Court, judges of the present, the chair lady of the Nairobi Center for International Arbitration, and the registrar, fellow arbitrators, colleagues, good morning.
Good morning.
It gives me pleasure to introduce to you today the panel that will discuss the issues that have been covered in the speech that have been given by the Honorable Chief Justice. I must say that the assurances that have been given to us today regarding the attitude of the court towards arbitral awards is music to our ears. It is really important that we hear the head of the issues that our courts are all pro-arbitration. Let me not steal the thunder from the people who will discuss this issue, but allow me just to say make a few points, and then I will invite my colleagues to come. This issue of enforcement of arbitral awards is really critical because enforcement is the confluence, the intersection between three critical players in an arbitration: the parties, the arbitrator in the form of the arbitrator's award, and then the courts. So you have had a situation where there have only been two parties involved, the parties themselves and the arbitrator. At the point of enforcement is where you have the courts coming in. And as is always said, the effectiveness of a dispute resolution mechanism is determined by the ability to enforce the final outcome of the award. So that if the parties have gone through an entire process, they have spent time, they have spent money, if then that award is not enforceable at the end, then it's not an effective dispute resolution mechanism. We can put it in the Constitution, we can put it in the statutes, we can write it in articles and say how important it is that awards are enforced. But if the courts do not enforce those awards, then the effectiveness of the dispute resolution mechanism becomes fails. Now, the importance, I must say, of this conversation is that while initially there was a lot of tension between the judiciary and the arbitrators in terms of resolution or hearing of matters, that tension has somewhat dissipated, I must be able to say. But the discussion we are having today is to find out what is the current landscape, what is the attitude of the courts, not just in Kenya, but in Africa and other areas, to this whole topic of enforcement. What are the hurdles that need to be crossed? What are the challenges that are being experienced? What are the lessons that we can learn from how others have handled this situation? Because it's not a Kenyan problem. It is not an African problem. It is not a European problem. It's a world, it's a global issue. And it's a global issue because as the Nairobi Center for International Arbitration continues to encourage international arbitrations to come to this show, to this side of the show, and to this country especially, everybody will be watching how effective is the mechanism available in Kenya and in Africa to enforce the awards that are made not just here, but also the awards that are made internationally. And critically, you cannot say that you're very welcoming of arbitration awards that are made internationally if you don't enforce the ones here. Because the only test of the attractiveness of this area and ability of the courts to enforce the awards is how we enforce local awards. So the conversation that we're going to have today is how effective this has been, how the other countries have dealt with some of the issues that have arisen, and to help us in doing that, I have a panel of experts from various areas. We will hear from experts from Africa, from Europe, and from the Middle East, and especially the UAE. And the first panelist that I will call to come up is Ms. Njeri Kariuki. So I'll introduce them as they come so that I don't have to introduce them again. Njeri Kariuki is a partner in the firm of Njeri Kariuki Advocates. She is an advocate of 32 years. You will find her bio in the docket that you have. But importantly, Njeri has also been a tutor in tutoring arbitrators for many years. And she had the singular pleasure of teaching, among others, yours truly. And so welcome, Njeri. It's a pleasure to have you. Njeri has adopted West Africa, and so today she will be speaking to us from the West African perspective. I have requested that there's an additional name we can call her, because once we call her Njeri, it sounds Kenyan. We are still debating. All right. The second person that I will call up is Mr. Ahmed Ibrahim. Ahmed Ibrahim is a dedicated full-time independent arbitrator, mediator, and adjudicator. He operates from the Middle East. You will also find his bio in the booklet. He tells me that while he has wide experience from the UAE, this time the perspective you speak to us about is the Egyptian perspective. I have brought him immediately after Njeri because he's the other person that we need to discuss how he wants us to refer to him, now that today he's Egyptian, more than from the Middle East. The next person that I will ask to come up is Mr. Karim Mahmoud. He is a partner in dispute resolution team at Hadef and Partners in Dubai. He also has a very big CV that you'll also be able to find. Although he's from the UAE, I think today the lessons we're learning, people keep coming from places we didn't expect. Although he's from the UAE, he is trained in the US. But he will be giving us a perspective on the UAE and the Middle East. All I'll ask you to remember is that it's not the very UAE. The next person I've asked to come up is Mr. James Holden. He's a partner in the dispute resolution in the London office of White & Case, and he focuses a lot on international arbitration. He is from London, but he has asked me to also remind you that his practice, the main emphasis is on East Africa. So again, the European perspective, not East Africa. Thank you very much. Last but not least, absolutely, is Professor Gideon Muigai. Gideon Muigai is the Attorney General Emeritus. He's a professor of public law at the School of Law, University of Nairobi, and a senior partner at the firm of Mohammed Muigai LLP here in Nairobi. He will be speaking to us from the perspective of East Africa, mainly. Again, Professor Muigai had the singular pleasure also of being my lecturer. So, may I also say, my Lord Justice Smoky Mwanjala, I had the pleasure of being a student. So, without further ado, I will pose a few questions to the speakers who will come up and give their responses. I actually hoped we would be seated when we're having this conversation. I don't know if I can get a seat. Oh, good. Yeah. No, don't put me there. It's easier. Thank you very much. To set a stage, I will ask Jerry Kaluki, could you please provide us an overview of the typical process that is followed when seeking enforcement of an arbitral award, so that even as we are discussing how these arbitral awards are enforced, we have a foundational view of how this is done.
Thank you. I know the reason why we were asked to speak to this question is probably because some of you may not be so familiar with the whole process of enforcement of an award. I myself, not being a litigator, I may not be the most proficient, not coming before like Honorable Justice Manjala here and the ladies Justice here. But for the record, we have in the CPR Rule 59. This is what assists. Once you get your award, and because many parties are, some parties are, as far as I understand, are agreeable, don't have to seek enforcement. Others don't want to abide by their agreements under the arbitration, considering that arbitration is consensual. Always keep that in mind, it's consensual. So ultimately, having agreed to come before a tribunal, then you really should be bound by those obligations to also observe, once that award, the final award is imposed upon you, then you should really uphold whatever is contained in that document. However, parties are at times reluctant to do so. We know that things go downhill during the course of a reference, which then ultimately causes the party that didn't win to be unhappy, wanting to appeal, so on and so forth. However, the party that has succeeded, let's put it that way, will then approach the courts with whom arbitration partners. Okay, that's why we're always looking for support from the courts. Partners with the courts to have that award enforced. So under CPR 59, you apply for enforcement of, first of all, recognition. Of course, it's supposed to be slam dunk, but unfortunately, that's not the case. So you go through the rigors of applying for, not recognition, but for enforcement of your award through the courts. Regretfully, it does take a long time. I'm very impressed with, I think it was Mr. Karim's jurisdiction that says 30 days or else. Okay? Ours, we all know it takes 2 years, and I think we need to take a leaf out of Mr. Karim's book. Ensure that our awards are enforced within a shorter time. But anyway, you go through the rigors of you present your award, so on and so forth. You have to go before the court and have your award either enforced, accepted, or, as happens in many cases, it is set aside or remitted to the tribunal because of certain issues. Now, the best part about our act is that you cannot appeal on the facts. Okay? So, anybody who is not happy can only look for an issue of law, nothing more. You are not permitted as a court to delve back into the facts of that the tribunal has already accepted, delved into, so on and so forth. It can only be an issue of law that can be considered in the event that you appeal, and that you seek to have an award set aside. Now, this is where issues of public policy may jump up and so on and so forth, but we're going to discuss that further, I think, during the course of this morning. Issues of public policy, of course, you know that it's an unruly horse as per Ingera, so that is going to come up. Kamal, I can safely hand back to you.
Thank you very much, Jerry, for setting the stage for us. And in the course of the presentation, you mentioned UAE and how they deal with applications for setting aside, especially as it comes to speed with which they are resolved. And I think the useful lesson for us there, especially the judiciary, and how other countries have done it. So, Karim, can you just explain to us the situation in the UAE, and especially if you can give us the past and the present, and how the courts have tried to address this issue of delay in dealing with applications for setting aside of arbitral awards?
My pleasure. Good morning. A bit of a disclaimer, I'm sitting next to Ahmed Ibrahim, who has a great deal of experience in the UAE as well, including that of an arbitrator, so I welcome him to provide his perspective, which would be impactful. So I think for the UAE, it's helpful to give a bit of background. It's a country that's about 50 years old. 90% of the people that live there are not from there, right? So they're used to another jurisdiction, another way of doing things, another way of contracting. And so one of the things that's happened there is that they've created a separate jurisdiction, a common law jurisdiction within the UAE called the Financial Center Court, the DIFC. And what that does is provides an additional seat that's available for arbitration, as opposed to the civil law courts which are conducted in Africa. So, the moderator mentioned that there is this tension always between the courts and arbitration. I think I would agree with the comments that tension has dissipated over time. A lot of the issues that we've seen pertain to public policy, issues of authority, issues of procedure, and if you take a wide lens, you see that those issues have dissipated to a degree over time. So, generally speaking, what used to happen when you had a foreign arbitration award that you wanted to recognize, or even a domestic award, you'd have to go through the 3 levels of local court in order to get to enforcement. So the 3 levels in the UAE: Court of First Instance, Appeal, Decision. As my colleague mentioned, there's an issue when you have to appeal on both issues of law and fact. At the first level court in the UAE, you can appeal on both issues of law and fact. You basically get a mulligan. Excuse the golf expression. At the Court of Appeal level, you can only appeal on an issue of law. The point here is, after you've obtained and spent all this time going through arbitration, spent all this money, if you wanted to enforce in the UAE, you could potentially and would likely go through 3 levels of state court in order to get to enforcement, which could take potentially another 2 years, even if you spent years getting an arbitration court. So there's been a recent amendment to the Civil Procedure Code in the UAE, which has done away with that. So for a foreign arbitration award, you can go directly to the execution court and enforce directly. Now, there's a few requirements. We have to get everything translated, attested. Informally, the courts are requiring that you get a certificate of finality from the arbitration center. Some arbitration centers understand and provide this easily. Some, there's a bit of back and forth to explain what you need. But again, this is not a formal requirement. It's just something that the local courts feel more comfortable having. Just confirming that there is no appeal possible and that this is a full and final arbitration award. So once that is obtained, and that process itself can take time for anyone who's done cross-border work, getting something legalized and attested, and then there's a process domestically. Once we receive that legalized and attested award, it has to go through the Ministry of Foreign Affairs, Ministry of Justice, everyone gets their stamps, and then you're at a point where you can submit. Now, when you submit to the UAE execution court, they're supposed to provide a decision within 30 days. which is great. You can take this foreign award and potentially turn this piece of paper into something actionable to get some funds or attach assets or identify where assets have gone within 30 days. Now, it doesn't always happen within 30 days, and there's little recourse if it takes a little bit longer, but that is a stark difference from what we were used to, which is potentially going through multiple levels of appeal before even getting to the execution court. So that's just, in short summary, where we've come over the past few years.
Thank you very much. So, even as we discuss this whole issue of how the courts deal with awards and whether, in fact, they are pro-arbitration, the circumstances under which sometimes they set aside awards on grounds that we may not say exceptional grounds. Maybe I want to hear an example from you, Ahmed, on the Egyptian courts. I think there are a couple of decisions that were rendered where they have set aside on very interesting grounds. So if you could just take us through that so that we understand why this conversation is important and why we find experiences from other areas how this issue arises.
Yes, of course. First of all, we have to distinguish between, if we are talking about setting aside, that's a process for domestic arbitrations, so arbitration seated in Egypt, as opposed to the enforcement of foreign arbitral awards. When we are talking about enforcement of foreign arbitral awards, the question is whether the country will refuse or accept the enforcement of the award. Speaking setting aside, that's only relating to domestic arbitrations. In general, Egypt is considered to be a pro-arbitration jurisdiction. It's an arbitration-friendly jurisdictions, and in the majority of cases, the awards are enforced by the judiciary in Egypt. But of course, from time to time, you see some decisions that break the bill. And raise debates among practitioners. For instance, the Court of Appeal recently refused or set aside an arbitration award because it's an ad hoc case. The arbitrators issued the award in the name of people. And the Court of Appeal considered this as a misleading statement because arbitrators do not have capacity to speak on behalf of people. And the formula in the name of people is the formula usually used by all judgments from the judiciary in Egypt. And therefore, the Court of Appeal considered that this is not appropriate and giving a misleading statement, and on that basis, set aside the award. This decision is subject to an appeal before the Court of Cassation at the moment. Speaking for myself, in my view, the Court of Appeal took it to the extreme by setting aside the award. Yes, it should be criticized that arbitrators should not issue the award in the name of people, because that's not true, but this, in my view, shouldn't be a reason or ground to set aside the award. And ironically, some 10 years ago in Qatar, the State Court of Qatar set aside an award because it was not issued in the name of Amir. So the award didn't follow the formula used by the judiciary in Qatar. So it's this or that. So you have to tell us whether we say in the name of anyone, people or Amir or anybody, or just try the award. That's one of the decisions. Another one, which I consider a backwards, unfortunately. As you know, in Egypt, there is a requirement for the government contracts to be signed by the minister in order to be arbitrable, in order to validate an arbitration agreement. So any arbitration agreement that is not signed by the concerned minister, and the minister cannot delegate anyone else, he should sign himself. So from a practical point of view, this is very difficult to do with so many contracts, and especially with foreign investors and foreign companies doing business in the country. Recently, there was an award issued in favor of a Spanish company against a governmental entity, and the court set aside the award because it was not signed by the minister, which I'm not very happy with this decision. The third one that I like the most, there is a ground in the Egyptian arbitration law to challenge an arbitration award. This ground says if the arbitrators applies a law that is different, a governing law that is different than what the parties agreed upon. So for the local court to consider whether or not the arbitrators applied the governing law, the agreed governing law or not, they will have to open up and review the award to some extent. In this award, the arbitrators awarded damages for 100 million Egyptian pounds. And they described a breakdown of the amount for the damage. Actual loss, 25 million Egyptian pounds. Loss of profit, 25 million Egyptian pounds. Loss of opportunity, 25 million Egyptian pounds. Moral damage, 25 million Egyptian pounds. Wow. So under the civil code, you cannot award damages this way. You have to substantiate and find the grounds for the damages and assessment of damages. It's not like cutting a piece of pizza like 4 quarters, 4 slices. This is what the arbitrators did with this assessment of damage. And therefore, the court considered that the arbitrators, although they stated in the award they are applying the Egyptian law, the court considered that, no, this is not an Egyptian law, this is something else, and they set aside the award on that basis. That's one of the interesting decisions.
Thank you very much. I know those are interesting scenarios. I think it puts us on guard for judges to be careful, because lawyers can come up with all manner of arguments as to why their word is to be set aside. Obviously, when I say that sitting here, I'm an arbitrator, I'm not a lawyer, so. But, Professor, everybody that has spoken has looked at this issue from the perspective of the considerations that national courts take into account. And the word public policy has been referred to by almost everybody. And in Kenya, that has become a really big issue. You know quite a number of decisions that have been rendered on this issue. And the number of lawyers that have gone to court applying to set aside on public policy, including with reference to the Constitution. From your perspective, if you could briefly explain to us what factors might lead a state court to apply the public policy exception, and in your view, what is the potential impact of widening this public policy exception, especially given what the courts have said that it's an unruly horse and that it cannot be controlled in terms of saying this is the entirety of public policy?
Yeah, thank you, Mr. Moderator. In my view, in Kenyan law, we have 2 distinct problems in the area of public law. One that we are not concerned with this morning, and it's called public participation. It is the unruliest of all horses that you can think of. Any lawyer who has absolutely no basis of challenging any law or policy, his last refuge is something called public participation, which has suggested that Parliament, we do not have a representative democracy in Kenya. We have a democracy where the people we have elected must continue coming back to us on every question and asking us what our views are. And no matter that that view may be in the minority, it can be prosecuted as a view that was ignored. Now, arising from that same subculture, we have the issue of public policy. We were taught many years ago in the area of administrative law, where this issue first arose, public policy is an unruly force, for a very good reason. It is not an objective criterion. It is a very subjective criterion. And therefore, it is against public policy if, in the opinion of the judicial officer before whom the issue is raised, there is a violation of what, in their opinion, must be a moral standard, an ethical standard, or a cultural standard. Now you can see the danger with that, because there will be as many moral standards and ethical standards and cultural standards as there are judicial officers. In Kenya, it is compounded by another problem. As our teachers taught us many times, the road to hell is paved with good intentions. We made a constitution here that what we thought was a constitution to solve all problems. All problems. Political problems, social problems, cultural problems, economic problems, and legal problems. So a Kenyan lawyer begins his submission, as by the way, as a Kenyan judge. We both speak the same language. In 2010, Kenya bequeathed itself a transformative road. Now, the road down that proclamation is very interesting, because then it goes on to say that the Constitution has some sort of clarity in the, regarding the world we should live in, and that world is certain, it's clear, is unambiguous. It is not true. When lawyers use it, they say that the arbitral award is in violation of the public policy of Kenya. Where shall we find the public policy of Kenya? The Kenyan lawyer will tell you, in the Constitution. Because the Constitution has said Kenya is a democracy, Kenya is power derives from the people, and power is delegated to Parliament, including to the judiciary, and the judiciary must supervise inferior tribunals, and an arbitral tribunal is an inferior tribunal. Now that is the beginning of the problem. Because then the argument is lost, and that Kenya is party to a treaty. And the UNICITRO treaty, which created our arbitral law, is a treaty that Kenya must obey, and a treaty that the Constitution of Kenya recognizes as having the force of law in Kenya. The UNICITRO model recognizes that judicial intervention is the exception, not the rule. Indeed, it recognizes that all things being equal, the judiciary should not interfere with the arbitral process. The public policy brigade starts in the other direction, that the arbitral tribunal is an inferior tribunal subject to the supervision of the High Court. Meaning, it is not only a supervision relating to process, it is a supervision relating to substance. Meaning, therefore, that you can reopen the entire arbitral award as to the correctness of the reasoning. In my very humble view, that is wrong. And then we import the value systems that we are calling public policy. And we say, how many times did the arbitrator adjourn the proceedings to allow the defendant, the respondent, to participate? 3 times he refused to adjourn the proceedings. Now that is not good. That is against public policy. In Kenya, we recognize a fair hearing. So a fair hearing must be how many adjournments? 5, 10, 15, and down that road there is absolutely nothing but chaos.
Thank you very much, Professor. It's an interesting perspective that we see of the dangers of public policy application, the application for setting aside. But that deals with mostly domestic arbitration issues. So it's an in-house issue we're dealing with in Kenya. But then what happens to when international players come to Kenya to try and enforce the awards? James, I wonder, from your perspective, as you know, recognition is a precursor to getting enforcement. So in your view, what steps do states take to recognize foreign awards, and what factors influence this decision? And probably when you're also commenting, maybe if you have a perspective on what can be done better. Thank you.
Sure, so thank you. So obviously, as we've kind of touched on, the first steps towards recognition are normally formalistic. Translating the award into the local language, that's obviously a kind of necessary thing. You can't have a court judgment based on a foreign language award. I think everybody accepts that. But I think we've seen from some of the examples that, what those requirements are can vary a lot between jurisdictions and actually can start to create a barrier to enforcement and recognition. So I think the first step is that ideally we want to have as few formalistic requirements towards recognition as possible. So the idea should be to allow these arbitral awards to be turned into local court judgments that can be enforced as easily as possible. Now, under English law, which is kind of broadly consistent with, I think, a lot of pro-arbitration approaches, particularly in Europe. There's kind of 2 key aspects to consider as to whether an award should be recognised. The first is whether the tribunal actually had jurisdiction to make this award. That's a fairly obvious point that I think we all need to make sure of in the first place, but in general, that is an easy one to prove and to show. And then the second step is whether there was any serious irregularity in the way that the award was provided. Now, to be clear, that is not a question of the way that the facts or the law were determined. This is purely to look at the way that the arbitrators acted. Was there any breach in the arbitrator's duties to the parties, or did the arbitrators somehow act in excess of their powers? So an example that we've kind of heard already would be that they applied a law that was not the law of the contract that the parties had agreed. So it's looking at it very much from a procedural perspective. And I think, going back to something the Professor was saying, it's all well and good to have those things written down and to have them, being relatively narrow. But I think the key is that you also need the judiciary to apply those very, very narrowly, very restrictively. The English courts have repeatedly said these bases cannot be used as a kind of backdoor to reopening any factual or legal arguments. That's not what they are there for. And we've consistently seen in the UK that only about 5% of applications that are made on these 2 grounds are actually successful. That's the kind of very high burden that's being provided. Now, English law does also provide a third ground. That is that you can appeal on a point of English law having been determined incorrectly. If it's a point of foreign law, you haven't got a chance. The key to know on this one is that actually under the Arbitration Act in England, parties can opt out of that entirely, and most institutional rules provide that as an automatic thing. If you adopt the ICC rules, it's waived. So actually, it's not a ground that comes up very often, because in most cases, it's already been waived by the parties as a ground upon which you can, try and avoid recognition. But again, when it does come up, a very high burden is placed upon it. So you can't just say, oh look, there was this point of English law and the tribunal got it wrong. It has to be a point of English law that actually went to determining the substance of the dispute and was determinative of the award that was made. It has to be obviously wrong, so it's not like a point that you're arguing the minutiae of English law. It has to be very obviously wrong, and on top of that, it has to actually be an important principle of English law that has been determined. So again, there are steps upon steps to make sure that this is not being used as a way to reopen arguments over the case. And again, we've seen that about 5% of these applications succeed. So it is at every stage of the process a pro-arbitration approach. And some of you may know that we've recently been going through a review of the Arbitration Act and potentially updating and amending it. And one of the key reasons for looking at the Arbitration Act, and one of the requirements of the panel that was looking at it, was to look at ways that the Arbitration Act needed to be updated to make it more pro-arbitration, to make sure that England, in our new Brexit world, was continuing to maintain its pro-arbitration approach at the highest levels, because it is seen as, being a positive for the country that we are seen as pro-arbitration. So that is, I think, key. Now, another common consideration can often be what was done at the seat, what the courts at the seat of the arbitration determined. Often, if the courts at the seat have set aside an award, then that is followed by all the other courts where you try and enforce. But interestingly, from a European perspective, the French courts have very much gone their own way and determined that they don't care what's happened at the seat of the arbitration. They will look at an award from a purely French perspective and see whether the French test has been met. They don't care about any other court. So that's that's a really kind of very extreme pro-arbitration approach. Then beyond those, you've got the New York Convention, obviously, and there are the kind of 8 grounds under the New York Convention. I don't intend to go through all of them. Some of them overlap with the things we've already been discussing. Obviously, it is, as the professor was saying, the public policy ground that is often the one under the New York Convention that gains most traction. And again, I would just say that I agree with what the professor was saying, that the courts just have to take a very strict approach to that. That is the idea of the New York Convention. It's not that you try and find clever arguments to become public policy angles. So in England, for example, there have been cases where arguments have been made that, look, under English law, the contract that this arbitration was the subject of is actually illegal. An English court would strike it down for corruption, for whatever. And English courts have said, we don't care. That's not a reason why this contract should not be awarded and the award upheld. If the arbitrators didn't find that there was any corruption, and if it was legal at the place where it was performed, then the English courts don't care that under English law it couldn't be enforced. It was legal there, that's fine, and the award is recognised. So I think that is the key at every stage, is really to restrict the view, to keep it as narrow and as focused upon the precise words as possible, and to always be trying to look at the case through that pro-recognition, pro-enforcement lens.
Thank you, James. There's a follow-up question. I understand that under English law, there is an issue regarding consumer protection, and that it is an exception when it comes to enforcement of awards. Now, in Kenya, we have the Constitution. Is consumer protection in UK the problem?
So you're right, this is an area where now the English courts have slightly taken a different view and started to apply public policy exception. Now, under English law, there is this thing called the Consumer Protection Act. It is meant to, it is only relevant to a limited scope of cases. So it is where a consumer, an individual person, one of us acting as ourselves, not through any kind of professional capacity, has purchased goods or services. And the idea is to kind of provide protection to the English consumer and to make sure that they have a right to come to the English courts if there's been a problem. Now, there have been some instances, particularly actually with, in relation to US purchases made by English consumers, where the US companies include in an arbitration clause, and then the English courts have refused to acknowledge that award in the UK because it's gone against the protection of consumers that's provided under English law. But again, that is a relatively restrictive approach. There is a very distinct definition of what an English consumer is. I am not an English consumer if I go and buy something at the airport on my way home. I'm buying something in Kenya, I'm not protected by English law just because I'm English. So there has to be a connection that brings the transaction back to England. And obviously that now we trade so much electronically, you can buy things on the internet, that can raise some issues. But it is, I think, it is an issue that is causing some discussion in the UK because it is kind of a different approach to public policy than we have seen before. But I think it's a very limited exception. And unlike the Constitution, which can be a very broad document that allows you lots of avenues to make arguments, I don't think this is going to be something that has a wider application, particularly to business relationships.
Thank you very much. So, as we look at how domestic courts or state courts handle arbitration awards, Ahmed, where there is an attempt by parties to resist the enforcement or frustrate the enforcement of awards, can you share with us what are the options available to a state court? And if you have any experiences that you can give us, that would be very useful.
Yes, sure. Before I comment on this, I would like to make a quick comment on what James said with regards to the French court approach. There is a very interesting case known as Bechtel case. I would like to invite the audience to read about. In the Bechtel case, it was seated in Dubai, and the Dubai Court of Cassation set aside the award on the ground that the witness has given evidence without taking an oath. And the court in Dubai considered this to be a point of public policy against public policy, and therefore the award was set aside in Dubai. The party sought, the winning party sought to enforce the award somewhere else, and it was accepted by French courts. And French courts said, we don't care if the award was set aside in the seat. Swearing an oath is not is not a material point in our jurisdiction, so they accepted to enforce it. I think this is a very interesting case to read about. Back to your question. The enforcement process in Egypt is before the enforcement court. Let's call it enforcement court. And the enforcement court is just to say, this award is enforceable or not. So to accept, to enforce or not. But the enforcement court does not have any powers to take any specific measures to ensure the enforcement. Once you have an order for enforcement as a winning party, you will reach out to the other party, the losing party. If they pay, that's fine. If they resist or try to obstruct the payment or enforcement, then you will file execution proceedings before the execution judge. The execution judge has a wide range of powers, including seizing assets, goods, and placing attachment orders over bank accounts, and all the way to sell out the assets in public auction and use the money to settle the awarded sum. One interesting case I was involved in as counsel. This was like 6 years ago. I obtained a favorable award in favor of my clients in an arbitration seated in Dubai. And the assets of the losing party was in Egypt, and we wanted to enforce. So we tried everything, and there was an attempt to frustrate the enforcement by way of obstructing, trying to avoid notification, proper notification, etc. At the time, I instructed an Egyptian litigation lawyer to help us with this enforcement, and he came up with a very good idea. The losing party was a publicly listed company in Egypt. So, by law, if a publicly listed company received a notice of bankruptcy, they will have to report to the capital market, which will have a very bad impact on the price of the shares. It will drop dramatically, of course, because of the reputation. So what we did, we filed the bankruptcy proceedings on the basis that this company stopped paying its debts, which is a valid ground under Egyptian law. Once they received the notification, they give us a call and they pay next day. So that was a piece of experience that I wanted to share. So perhaps you can use it in Egypt if you have an award to enforce. Back to you.
Thank you very much. But as we look at how enforcement of awards are made at the end of the hearing, there are steps that will probably be taken in the course of the hearing, in respect of which we need the assistance of the courts, and how the courts can aid us in this regard. And increasingly, I've seen many applications for interim measures of protection, anti-suit injunctions, and so on. Jerry, could you just discuss briefly with us these options that are available, and whether in your view, these are options that we should be dashing off to court, or should we be telling the arbitrators to deal with them?
Well, doesn't it depend on what the overarching law says? Because that is our guide. As I said initially, the courts are our partners as tribunals, as arbitrators. To assist in the process of arbitrating. So if the act, or the overarching act, and most jurisdictions that are pro-arbitration loosely or maybe wholesale have applied ancitral, which then encourages the courts to assist tribunals in the process of a hearing or arbitration. So yes, I think we must seek where the court where the act so dictates, that we should seek the court's assistance in injunctive relief, anti-suit injunctions, so on and so forth. And where I have, for instance, Nigeria and Ghana those two, being pro-arbitration, will the courts do take a non-interventionist approach to arbitration and indeed only assist where things like this are concerned. So it's not across the board. You see, you have to take into account that several countries in West Africa have not either brought in anything to do with arbitration, and even have not accepted the New York Convention. Now, the OHADA countries, which are 16, have based their act on a loosely, they have based their act, the OHADA Uniform Arbitration Act, very loosely on ancestral, which means basically just the same way the English have broadened their 1996 and now are even seeking to become more pro-arbitration. It means that OHADA has a favorable regime for recognition and enforcement of awards. So even in this case, the courts will provide that support to arbitral tribunals where interim measures of protection, injunctive relief, so on and so forth are required. So I would say yes, we should continue to do so, and I think courts being a partner are then not to be obstructive. They are to assist. I mean, like we have summons, when we seek summons for witnesses, so on and so forth, it is for the courts just to accept, well, interrogate where necessary, and allow the process to continue. James.
Thank you very much. Karim, one of the things that we have seen increasingly in this jurisdiction to try and sometimes delay or prevent the progress of matters is to apply for the removal of the arbitrator, opposing the appointment of an arbitrator. I don't know whether this is an experience you have in the UAE and how you think the court should deal with that, with such a challenge.
Well, there's often jurisdictional challenges. Fighting the appointment of an arbitrator falls within that. It's appealable to the Court of Appeal on shore, which is, then again, you can go up to the Court of Cassation. So there's a process for it, there's a mechanism to deal with it. Usually it plays out the way you would expect. I mean, it's not, that is not so much an issue, in my, maybe as another view, but we expect jurisdictional challenges regularly. You know, this tension that we were discussing before, I believe has dissipated over time. I mean, there's been a lot of challenges that we used to see that there's been an adaptation either by arbitrators, by the courts themselves, or by legislation. And I can give you some examples of that. In terms of legislation, one of the things that you could not arbitrate on is agency disputes under the agency law in the UAE. So agents in the UAE are afforded special protection. They register their distribution agreement, and you basically can't cancel it or terminate the relationship. It's very, very difficult to do. And so even if you had an arbitration clause in that franchise or distribution agreement, but you know, the agency law would supersede. Now that has changed very recently, which is a massive development in that space for us. I mean, it's been something that a lot of people are looking into, how to change the relationship that they've been stuck in for a very long time. And even if someone's not performing, how to get out of it. So that's just a small example from a legislative side. From a procedural side, you know, one of these small tactics that people would use is challenge on the fact that not every page of the award has been signed, right? And if you, I used this joke before, so excuse me, but if you shake Ahmed's hand, it's got a very firm grip because of how many times he's had to sign a page of an arbitration award. And, you know, so arbitrators have adapted, right? And everyone signs every page. And even the section of relief You know that important page that when you open the award, you just scroll directly down to see whether you won or not. That has to be, it shouldn't be on a separate page. It should be continuous from the merits discussed. So small things like that, and arbitrators have just adapted. The courts have also adapted. There used to be a lot of challenges on authority. So you complete the entire arbitration process, you're looking to enforce, and then the other side raises an issue of, well, the person who signed the arbitration agreement, or the agreement with the arbitration section in it, he didn't have proper authority. What does that mean? I've been negotiating with that guy for 1.5 years. He's a manager listed on the company. Why would he not have authority? Well, the Articles of Association don't provide specific authority. Well, I don't have the Articles of Association. Why would I know that? I mean, there should be an understanding of apparent authority. So the courts accept this now, right? And initially, this was something that was it was successfully challenged, and then as things progress, if you look at through a wider lens, this is something that the courts have understood and now adopt. So that's just three key examples.
Thank you very much. Ahmed, you wanted to talk to that?
No, Karim covered everything actually, and on the point of authority, it was really a problematic point for some time, because especially arbitration is very common in real estate transactions in the UAE. So imagine someone is buying a property, a one-bedroom apartment from a big developer, and standing in a very long queue, waiting for their turn to sign the contract for the apartment, and he would ask, please give me a special power of attorney to give you the power to sign this arbitration clause. Of course, no one would do that. So the court at the beginning didn't appreciate this practical issue and set aside, unfortunately, a lot of awards on the basis that the person who signed the sale agreement from the developer side didn't have the authority. But now this was sorted based on the apparent authority principle.
Thank you very much. Very interesting perspective from the UAE. Prof, if you look at it from the Kenyan perspective, I think in section 14 of rights of removal of arbitrators, it has become common now for people to go before the arbitrators, he recuse himself, he refuses, they go to court and apply for the removal of the arbitrator. What has been the experience in this situation, and how do you think courts should deal with such situations?
Mr. Moderator, so far I have not been removed. So I am happy with the way the courts are exercising their jurisdiction. I think that my own understanding of the law is that an arbitrator ought not to be frivolously challenged, inasmuch as a judge, to impeach a judge in a matter must be grounded on very, very, very solid grounds. And I have had this discussion with my friends in the judiciary, and I have said many times that you may think that you are achieving a good thing by saying to a vexatious litigant, take your file away. If you don't want me to hear you, I have other work to do. The truth is that the consequence of that is to create a culture in which unethical lawyers achieve a collateral outcome. And I think that the rule is the same. I don't think an arbitrator ought to recuse themselves on flippant grounds. I have had people say, the arbitrator was a classmate of my opponent. Now, if you start that way, we are a very, very small profession. Everybody was somebody's. We are related in very, very many ways, all of us. As the learned judge of the Supreme Court said earlier on, we have visited many countries together and shared a lifetime of experiences. Having said that, I think that an arbitrator ought to recuse himself if there is, on the face of the record, reason to believe that a third party looking at the facts and the circumstances would have a doubt that he would be impartial. And I think that that is the same rule that a judge should use in reviewing the arbitrator's exercise of discretion. Now, I just want to wrap up by saying the best arbitration centers in the world are not the best because the arbitrators are the best. They are the best because the judges are the best. And if you look at, the UK is such a strong arbitration center globally because the commercial courts of England are very, very strong, and they make the arbitration process very smooth. The same is true of those islands. Singapore is another very, very, very strong arbitration center because the judiciary is a very, very strong commercial judiciary. So I agree with Njeri when she says that the relationship between the judiciary and the arbitration profession is very, very critical. Where the judiciary is weak, the arbitration whatever cannot take root. I arbitrated a matter for several years in a neighboring country, a huge dispute involving a bank. And the judiciary was so weak that it was impossible to make progress. For as many times as the tribunal tried to move forward, an order of some sort or other issued from the judiciary, and eventually we had to abandon that center. So I am happy that in Kenya we are we are in your very happy circumstances. Our relationship with our commercial court has grown stronger and stronger, and the court is a partner, not a hindrance.
Thank you very much. You can see the risk of sitting next to your teacher. He wants to be reminded something. So the reason why I think this last discussion we've had is important is one of the grounds that increasingly is coming up in application for setting aside is a propriety on the part of the arbitrator. And so people cite the fact that I even applied for his removal, he refused to recuse himself and so on. So that conversation of how to handle applications based on the request for removal of the arbitrator becomes very important. Now, this stage, I think we have reached a place where we can now take off on the next discussion, which will delve into more examples on areas that we have started off with. I was ready to do that, but I'm told that tea has been served, and the servers want us to move to that stage. So we'll take a break at this time for 15 minutes only, and then come back and continue with this very engrossing conversation on an issue that is of paramount importance to us. So I will see you back here in 15 minutes.
We thank the panelists for the engagement so far. For me, it has been interesting to hear the different grounds and tactics upon which parties are now imploring in order to set aside an award, and the adaptations undertaken by the tribunals, the lawyers and so forth in order to avert this issue. As Mr. Karori has advised we'll be taking a short health break now, just for 15 minutes. We can go grab our teas at the terrace and aim to be back here by 11:20 a.m. And just before we break for tea, I wish to recognize the sponsors of this event, the International Development Law Organization, IDLO. And just for a short while, please allow me to invite the country representative of IDLO, who is here with us, Ms. Teresa Mugaza, who is going to make her remarks before we break up for the tea break.
This is what being set up for failure is called. I'm asked to be the person that stands between you and tea. So I'm not going to make remarks, but I'm going to say thank you very much to our able panelists. I had the privilege today of sitting and actually learning, I think, from industry experts, and I'm inspired in my next life to pursue arbitration. On behalf of the IDLO, we'd really like to say we are pleased with the partnership that we've had with Nairobi Center for International Arbitration and, of course, Judiciary in Kenya. For those of you that are not familiar with us, IDLO is the International Development Law Organization. And actually, where I come from, I shouldn't even be speaking about IDLO because my board member, Professor Mugai, is here this morning. So I shouldn't be speaking. He should be speaking to IDLO. But just to say that as the IDLO, we work with institutions and people to reform laws and strengthen institutions. And one of the things we have done, because people will be wondering, you know, if you look at our mission, we say our mission is to champion people to justice and to promote sustainable development. So the question is, what are you doing in the space, for example, of arbitration? And the way we look at it is that, you know, for us, justice is not just about dispute resolution, but it's also about contributing to development, sustainable development for that matter. And in the case of IDLO, when we look at the work that we've done in Kenya, one of the things we've done is to support the ease of doing business. And part of it is how do you support institutions like the Center for Arbitration, like the Judiciary, to ensure that Kenya becomes an attractive business destination. And what we have done is, behind the scenes, in partnership with Kenya Judiciary Academy, and I'm glad to see Justice Wanjara is here, we've been working to support capacity building where we can. We've also been working to strengthen the policy and legal frameworks. And I'm proud to say, together with NCIA, we undertook the very long task of working on the ADR policy, which has now been adopted. And we hope to see that the mechanisms for arbitration will be improved, and of course, generally, alternative dispute resolution. And I think just to say that for me, I think what's critical is to always look at the law as a means to an end and not an end in itself. And how do we do that? We do that through various ways, as we've already heard. And I think for me, just as a parting shot to say, I think I'm more encouraged in doing the work that we do, because when I was listening to all the speakers speak, it's not always about the law. Sometimes it's about the processes. So how do we ensure that institutions and the individuals working are on par in terms of understanding the processes in a way that makes sure that alternative dispute resolution doesn't become something that you play with and make it look inferior to the judiciary, but becomes part of ensuring that justice is served to justice seekers. So without further ado, please let's go and enjoy tea, and thank you very much.
She's done.